Hello friends. So, am I audible? आवाज आ रही है? Yes, okay. So, we'll continue our discussion on general exceptions. In the previous class, we had finished until section 80. Now, moving ahead, now we have reached section 81. Today, our agenda is that we'll try to finish general exceptions today itself, because if then we'll try to uh, deal in detail every section, then it will turn out to be a foundation course. So it's better that we try to uh, fulfill the objective of the course by giving you a quick revision, a quick review of what all sections are there, what all important areas are there, so that when you are going to appear in this exam, the process of your revision becomes more easier and it takes less time as well. Okay. सो ये बात ध्यान में रख के हम लोग कोशिश करेंगे कि जल्दी जल्दी अपने जो है जो टॉपिक्स हैं उनको फिनिश करके उसके सिर्फ इंपॉर्टेंट एरियाज पे ध्यान रख के हम लोग आगे बढ़ें, क्योंकि क्रैश कोर्स का ऑब्जेक्टिव यही है हमारे. ओके. सो सेक्शन 81 डील्स विद द डिफेंस ऑफ नेसेसिटी. The title which is given under section 81 says that act which is likely to cause harm done without criminal intent in order to prevent some other harm. Meaning thereby, in conceptually this is also known as the defense of necessity. Meaning thereby you have the knowledge that you will commit an act that will likely to cause harm. But apart from that knowledge, the guilty intention, the criminal intention is missing here. Though you have the knowledge that the act you are doing might cause some harm, but you have done that act without the criminal intention and also in good faith. For what purpose? For the purposes of preventing some other harm. Now, whether the purpose of preventing or avoiding some other harm is whether the harm that you had committed with the knowledge for the purpose of preventing or avoiding some other harm, is it justified? Whether the nature of that some other harm that was prevented or avoided, was it imminent? That will depend upon the fact of the case. Section 81 also says that it is a question of fact. So that we'll see what section 81 talks about. It says that act which is likely to cause harm but done without criminal intent in order to prevent other harm. And to prevent other harm. Nothing is an offense. So it will not be treated as an offense. That is why we say that it's a defense of necessity. Meaning thereby, in order to prevent some other harm, in order to avoid some other harm, you had committed, with the knowledge, you had committed some harm, but without the criminal intention. And first and the foremost thing, that it has been done in good faith. Good faith agar missing hai, section 81 will not be available to you. It says that nothing is an offense merely by reason of it being done with the knowledge that is likely to cause harm. If it is done without any criminal intention to cause harm and in good faith for the purposes of preventing or avoiding other harm to the person or property. Okay. So very simply, the essentials are there, that knowledge might be present, that your act is likely to cause harm, but criminal intention should be missing and good faith should be present. And why you are doing this? To prevent or avoid some other harm. अब ये जो सम अदर हार्म है, it is not required that the other harm that is intended to be prevented or avoided should be bigger or smaller than the harm that has been knowingly caused. That is not required. कि कोई हार्म अगर आप प्रिवेंट कर रहे हो या अवॉइड कर रहे हो वो हार्म बड़ा होना चाहिए, ऐसी कोई रिक्वायरमेंट नहीं है अंडर सेक्शन 81. An explanation further clarifies that it is a question of fact that in such a case whether the harm to be prevented or avoided was of such a nature so imminent to justify or excuse the risk of doing the act with the knowledge that it was likely to cause harm. Meaning thereby, the harm that you have knowingly caused, whether the harm that you have knowingly caused in order to prevent or avoid some other harm in good faith without any criminal intention, whether the harm that you had knowingly caused, whether it is justified, whether causation of that harm was so imminent in order to avoid some other harm. It is a question of fact. It will depends upon the facts of the case which are there. Okay? So ये हो गया डिफेंस ऑफ नेसेसिटी, वेरी सिंपल. इसमें बस आपको दो चीज ध्यान में रखनी है, क्रिमिनल इंटेंशन नहीं होना चाहिए, और क्रिमिनल इंटेंशन नहीं है तो मतलब गुड फेथ भी होना चाहिए. सेकेंडली, आपने हार्म नोइंगली कॉज किया होगा, बट पर्पस क्या है? टू प्रिवेंट सम अदर हार्म, टू अवॉइड सम अदर हार्म. इसी को नेसेसिटी बोला जाता है. इसके इलस्ट्रेशंस आपको याद रखने होंगे. सेक्शन 81 में 2 इलस्ट्रेशन दिया है. शॉर्ट में अगर आपको बता दें, एक इलस्ट्रेशन डील करता है स्टीम वेसल से. हियर यू विल सी one illustration deals with steam vessel and the other illustration deals with fire that has been caused in houses. 2 illustration है. नेसेसिटी के डिफेंस में 2 इलस्ट्रेशन याद रखने हैं. पहला इलस्ट्रेशन है स्टीम वेसल से रिलेटेड, और दूसरा इलस्ट्रेशन है आपका कई घरों में जो है आग लग गई है उससे रिलेटेड. स्टीम वेसल से रिलेटेड क्या है? Meaning thereby, suppose you are navigating a steam vessel and without any fault on your part, you had exercised due care and caution. Suddenly, a situation arises in which you are about to run down another boat which is carrying 20 or 30 persons. However, you can turn the boat and put it in the direction of another boat in which only 2 persons are there. And this you have been put in this situation inevitably. This cannot be avoided. Then in that case, if you had run down the other boat which is carrying less person in good faith, with due care and caution, there was no want of caution on your part, without any criminal intention you had done that to avoid some other harm, then the defense of necessity will be available. So here it says that A, the captain of a steam vessel, suddenly and without any fault or negligence on his part, finds himself in such a position that before he can stop the vessel, ऐसे पोजीशन में आ गया है कि वेसल को स्टॉप करने से पहले ही इज इन सच अ पोजीशन दैट ही मस्ट इनएविटेबली, इट इज अनअवॉइडेबल दैट ही वुड रन डाउन अ बोट बी with 20 or 30 passengers unless he changes the course of his vessel, and by changing a course he must incur the risk of running down another boat C with only 2 passengers are there. Here if A alters his course without any criminal intention to run down the boat C and in good faith for the purpose of avoiding the danger to passengers in the boat B, he is not guilty for the offense. Okay, but knowledge was there. आगे यही बोल रहा है, though he may run down boat C by doing an act which he knew that was likely to cause that effect. That is why the title of the section says what? Title of the section says act likely to cause harm. Okay. So this is there. The other illustration which is there under section 81 deals with certain houses which have been caught on fire. मतलब घरों में आग लग गई है. Now to prevent that fire from spreading, to prevent the conflagration of fire from spreading, a person has pulled down certain houses. कुछ घरों को गिरा दिया कि फायर जो आग लगी हुई है घरों में वो आगे बढ़े ना, तो ऑफेंस अगेंस्ट प्रॉपर्टी नहीं होगा ये, बिकॉज हिज एक्ट विल देन बी एग्जेम्प्टेड अंडर सेक्शन 81. सो ये दो इलस्ट्रेशन सेक्शन 81 में याद रखिएगा. एक स्टीम वेसल एंड सेकेंड इलस्ट्रेशन डील्स विद houses that have been caught on fire. To prevent the conflagration from spreading, a person has pulled down certain houses. Okay. So this is about section 81. Now we come to important cases. Important cases क्या हैं इसमें? Section 81 के important cases Vida Menezes versus Yusuf Khan. Okay. So Vida Menezes versus Yusuf Khan is there. 1966 case. The harm which is reflected under section 81 and other sections which are there, they denote the physical harm. Vida Menezes case. Two most leading cases that you must always remember is, and you must have been remembering this case, R versus Dudley and Stephens. Dudley and Stephens. Dhonia Dadji case. Bishambhar versus Rumal case. This is important. R versus Dudley and Stephens is also important. R versus Dudley and Stephens में Lord Coleridge was the judge. This case is very famous. You must have known. The Mignonet case. A boy was there. He was stranded with some two other persons who were there in a ship. They had nothing to eat. And then they finally decided to kill the boy, Parker. They did not get the defense of necessity. And Lord Coleridge says that in all cases, when you are stuck in such situation, it's better that you should have, instead of committing such an immoral act, you should have sacrificed your own life. R versus Dudley and Stephens. Dhonia Dadji case is also very popular. टॉडी पॉट वाला केस जो है धोनिया दाजी केस है. टॉडी इंटॉक्सिकेटिंग ड्रिंक होता है, लोकली प्रिपेयर होता है, ताड़ी भी बोलते हैं, टॉडी. सो दैट पर्सन हु वाज देयर इन टॉडी फार्मिंग, somebody usually used to steal his toddy from the pot. So in order to detect the person who used to steal toddy from his pot, he placed poison. Defense of necessity accordingly was not available, because these acts were not done in basically the good faith. Okay. Then Bishambhar versus Rumal case is also there. In this case, the panchayat ordered a person who had molested a girl to get a shoe beating, and also he was ordered by the panchayat to be taken throughout the village with a blackened face. मुंह काला करके जो है मोलेस्ट किया था गर्ल को, मुंह काला करके जो है पूरे गांव में इनको घुमाया जाए, जूते से मारा भी जाए. ये था इस केस में. इन दिस केस द पंचायत was allowed the defense of necessity. The members of the panchayat who had ordered this punishment, they were allowed the defense of necessity because keeping in view the sentiments which were there at the prevailing circumstance, it was considered that this kind of punishment or treatment was offered keeping in view the interest of the accused himself. Had it not been there, there would have been other serious consequences that might have occurred. So Bishambar versus Rumal, Dhunia Daji case, R versus Dudley and Stephens, these are some of the important cases which deals with the defense of necessity. Okay. Now we come to other three categories of general exceptions in which there is no such mental element is there. Non compos mentis. Three categories are there in that. Either by the reason of age, a person cannot form the relevant guilty intention, or by the reason of insanity, or by the reason of intoxication. So these three cases have been covered under section 82 to 86. 82 and 83, section 82 and 83 deals with the defense of infancy. Section 84 deals with the defense of insanity or unsoundness of mind. And section 85 deals with the defense of 85 and 86 also deals with the defense of intoxication. In all these three cases, we see that the person who has if the person who has committed the offense is unable to know the nature and consequences of his act, then his liability is exempted. Okay. Firstly, we'll deal with section 82 and section 83. Section 82, as I have already stated in the previous class, deals with absolute immunity of a person below certain years of age. What is that age? If a person has committed an offense and that person is below 7 years of age, then he cannot be held liable for any offense. Because section 82 states that nothing is an offense which is done by a child under 7 years of age. Because generally, the children who are under 7 years of age, they are considered what? They are considered doli incapax. They are considered incapable of forming the relevant guilty intention to commit a crime. They are doli incapax. That is why they have been absolute immunity have been provided to them under section 82. Qualified immunity, however, is given to those children who are above 7 years but below 12 years of age. Meaning thereby, they can also get claim protection under general exception, provided they did not have sufficient maturity of understanding. मतलब 7 साल के अगर कोई नीचे है तब तो एब्सोल्युटली ही कैन नॉट बी हेल्ड लाइबल, लेकिन अगर 7 साल के ऊपर है और 12 साल से कम है तो वहां पे जो है क्वालिफाइड इम्यूनिटी दी गई है, वहां पे सफिशिएंट मैच्योरिटी ऑफ अंडरस्टैंडिंग देखी जाएगी. Sufficient maturity of understanding in order to judge the nature and consequences of his conduct. अगर उस बच्चे को जो 7 साल से ऊपर है और 12 साल से कम है, उसको ये समझ है कि जो वो एक्ट कर रहा है वो किस नेचर का है, उससे क्या कॉन्सिक्वेंसेज होंगे, उसकी समझ है, उसकी मैच्योरिटी है उसे, then the benefit of the general exemption will not be available to him. However, there might be a cases that even beyond 7 year and below 12 year, there might be a child who is unable to know the nature and consequence of his act, who is unable to judge the nature and consequence of his act. He does not have the sufficient degree of a sufficient maturity of understanding. Then the defense is available. Okay. So that is why it is said in section 82 just you have to prove the age, but in section 83 the facts and circumstances will be seen to ascertain whether the person was knowing the nature and consequences of his, whether he was understanding, whether he had the sufficient degree of understanding. So that is there. That is why it is qualified immunity. इसमें एक famous maxim है, quia malitia supplet actatem. इसका मतलब क्या है? Meaning thereby that the malice, yes, malice supplies the requisite age. अगर मेच्योरिटी ऑफ अंडरस्टैंडिंग है, मैलिस है, तो एज के डिफेक्ट को रिमूव कर दिया जाएगा. मैलिस सप्लाइज फॉर द एज. ओके, क्वा मलिशिया सेपलेट एक्टेटम. सो दिस इज अबाउट द डिफेंस ऑफ इंसैनिटी. इसमें सम इंपॉर्टेंट cases which are there. Only 2 cases I will reflect. Ula Mahapatra case that might be asked. Musammat Aimona case. These 2 important cases are there. अब कोई ऐसा केस पूछ लिया जो कहीं बुक में दिया ही ना हो, तो अगर आपका गलत होगा तो अगले का भी मोस्ट प्रॉब्ली हो सकता है गलत हो जाए, या फिर लकली अगर कहीं उन्होंने पढ़ लिया हो रिसेंट में. लेकिन दीज 2 केसेस यू मस्ट ऑलवेज रिमेंबर, दे डील्स विद द डिफेंस ऑफ इन्फेंसी. ओके, इन उला महापात्रा केस व्हाट हैपेंड वाज दैट एन 11-year-old boy was there, and by his conduct it was seen that he ran towards the deceased fearlessly and warned him that he will be cut into pieces. उसको थ्रेटन करते हुए उसकी तरफ भागा कि काट देंगे टुकड़ों टुकड़ों में. On an analysis it was found that his conduct necessarily shows that he had sufficient maturity of understanding. That is why the defense of infancy was not available to him. Similarly, Musammat Aimona case, girl was there. After committing murder, the girl hid in the field. So this conduct of the girl definitely shows that she had sufficient maturity of understanding as to the nature and consequences of her act. That is why the defense of infancy was not available. Okay, so that is all. Yes, malice, quia malitia supplet actatem. Malice supplies the defect in the age. Now we come to the defense of insanity. This is given under section 84. Very important section. Many case laws are there under section 84, and frequently it has been asked also in various exams. Very simple also. Now, act of the person of unsound mind has been covered under section 84. This section also deals with, conceptually it is known as the defense of insanity, defense of unsoundness of mind. So insanity which is reflected under section 84 is legal insanity. A person may be medically insane, but still he might be suffering from lucid and non-lucid intervals, and when he's suffering from those intervals, he might be able to comprehend that whatever he's doing is right or wrong, but he might be medically insane. So what this section 84 deals is, it defines in that unsoundness of mind, if it is there, in what circumstances, if an act is committed by reason of such unsoundness, then how far the exemption would be available. So section 84 क्या कहता है? Nothing is an offense which is done by a person who at the time of doing it, this is very important, that at the time of doing that act, the person by reason of unsoundness of mind is incapable of knowing the nature of the act, or that what he is doing is either wrong or contrary to the law. So nothing is an offense which is done by a person who at the time of doing of an act, just a second, who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of his act, or what he was doing was either wrong or contrary to the law. Meaning thereby, if at the time of committing any act, the person was suffering from unsoundness of mind, and by that reason of suffering from unsoundness of mind, he was unable to know the nature and consequences of his act, or whatever he was doing was either wrong or contrary to the law, then it will not be considered as an offense. मतलब ऑफेंस करते वक्त अगर कोई पर्सन है जो अनसाउंडनेस से सफर कर रहा है, अनसाउंडनेस ऑफ माइंड, इंसैनिटी से सफर कर रहा है, और उस इंसैनिटी की वजह से जब वो एक्ट कमिट कर रहा था वो समझ नहीं पाया कि उसके एक्ट का नेचर क्या है, उसके जो वो एक्ट कर रहा है वो गलत है, लॉज में प्रोहिबिटेड है, कॉन्ट्री टू लॉ है, वो समझ नहीं पाया, तब उसको डिफेंस ऑफ इंसैनिटी जो है दैट इज अवेलेबल. ओके, सो एसेंशियल्स वी अंडरस्टैंड फॉर द डिफेंस ऑफ द पर्सन ऑफ अनसाउंड माइंड. फर्स्टली दैट द पर्सन मस्ट बी ऑफ अनसाउंड माइंड. सेकेंडली he must be incapable of knowing that whatever he was doing was either wrong or contrary to the law, or he was unable to know the nature of his act due to such unsoundness of mind. Then the defense is available. Certain important cases in the defense of insanity that you must remember. Firstly, we have R versus Arnold. R versus Arnold case deals with what? The wild beast test. इसको लॉर्ड फेरर्स केस में अफर्म भी किया गया था. वाइल्ड बीस्ट केस क्या है? That if a person is under the visitation of God, he is unable to distinguish between good and evil, then that person cannot be held guilty of any offense. The wild beast test, R versus Arnold. This question might be asked. So some tests gradually they had evolved before the McNaughton rules, and eventually in 1843 we had a comprehensive law relating to the insanity defense, which was properly given in the McNaughton case, and accordingly it was incorporated in the Indian Penal Code also. So before that, these tests gradually they evolved. Wild beast test हो गया R versus Arnold में. Then Hadfield case है. Hadfield case. Hadfield case में कौन सा टेस्ट इवॉल्व हुआ था? Insane delusion test. Insane delusion test. R versus Arnold केस है 1724 का. हैडफील्ड केस है आपका 1800 का. हैडफील्ड केस में क्या है? इंसेन डिल्यूजन टेस्ट. देन वी हैव द बोलर्स केस. बोलर्स केस, दिस इज ऑफ 1812. In the Bowler's case, the test to distinguish between just and unjust was evolved. The test to distinguish between just and unjust. Then finally we have the McNaughton case. (1843) इसमें कौन सा टेस्ट इवॉल्व हुआ था? मैकनॉटन्स रूल. Okay, and sufficiently the law which is there under section 84, it some way or the other it incorporates the McNaughton's rules which is there. Okay, it is in tandem with that. So R versus Arnold case, ये था this case related to attempt on the life of Lord Onslow. In this case wild beast test was involved. Hadfield case was there. This case is also related to attempt on the life of King George III. In this case, insane delusion test was there. Bowler's case was there. And then in 1843, the McNaughton's case is there. In that, accordingly, the McNaughton's rules were laid down. We see that the McNaughton case is very popular. इसमें क्या हुआ था? A person was basically under a delusion. He thought that Sir Robert Peel was going to hurt him, and mistaking Edmund Drummond for Sir Robert Peel, he basically attacked him and caused his death. यहाँ पे आप देखोगे McNaughton's case. And then when the case reached, accordingly, comprehensive guidelines with respect to the defense of insanity was accordingly laid down. Okay. R versus Arnold is there, Hadfield case is there, McNaughton's case is there. McNaughton's case में judge was Justice Tyndall. Arnold case में judge was Justice Tracy. Hadfield case was there, and then Bowler's case में the judge was Justice Lee Blank. In McNaughton's case, Justice Tyndall was the judge, and the case was defended by Justice Cogburn. Crucial in this case, the fact was that the accused believed Sir Robert Peel, the then Prime Minister of the UK, had hurt him, and he mistook the Edmund Drummond, who was basically the secretary of the Prime Minister, for Robert Peel, and he killed him with a single shot. The medical evidence revealed that the accused was suffering from a sick hallucination and insanity, which was beyond his control. And then accordingly, the test was laid down regarding the defense of insanity, and accordingly it was incorporated under section 84. Other cases which relates to the defense of insanity, you can remember the name. Directly a question can be asked whether this case law is related to which of the defense. Daya Bhai Chhaggan Bhai Thakkar case is there. R versus Sullivan is there. R versus Bailey is there. Sudhir Chandra Bishwas case. Hari Singh Gond case. This is important. Sudhir Chandra Bishwas case and S. Tuba Chetia versus State of Assam case. This case has been frequently asked many times. S. Tuba Chetia versus State of Assam deals with what? Difference between legal and medical insanity. So this is there. Okay. So broad conceptual outline of section 84, the defense of insanity, we have understood. Some important case laws we have understood. And then mostly our job is done. Okay. Rest is only for studying in detail. Maybe for the mains you can study these topics in detail. But for the prelims point of view, this would be sufficient. Now we come to the next defense, that is the defense of intoxication. So the defense of intoxication again has been dealt under section 85 and 86. 82, 83 infancy, 84 insanity, 85 and 86 deals with the defense of intoxication. Meaning thereby, what is the defense is all about. Section 85 basically deals with involuntary intoxication, and Section 86 covers the cases of voluntary and involuntary both. So Section 85 provides a valid defense if any person has been intoxicated against his will, without his knowledge, involuntarily. ऐसा नहीं हुआ कि खुद से गए and you got yourself intoxicated and you have committed a crime. It will not be a valid defense. But however, if involuntarily you have been intoxicated without your knowledge, against your will, and by reason of such intoxication you are incapable of knowing the nature of your act, or whatever you are doing was either wrong or contrary to the law. तो ये सेक्शन 84 से यहाँ पे मिलता है. देखिए, incapable of knowing the nature of the act or that he is doing was either wrong or contrary to the law. Then the defense of intoxication is available to you. So section 85 says that nothing is an offense which is done by a person who at the time of doing it, again, at the time of doing it. By reason of what? Section 84 deals with by reason of unsoundness of mind. Section 85 deals with by reason of intoxication. So by reason of intoxication, you are incapable of knowing the nature and consequences of your act. The nature of your act or what you are doing was either wrong or contrary to the law. Then, provided that the thing was intoxicated to him, was administered to him without his knowledge or against his will. So the intoxicating drink which was there, or intoxicating substance which was there, was administered to him without his knowledge or against his will, and by reason of such intoxication, a person committed an act, and by reason of such intoxication, he was unable to know the nature of his act. Then the defense of intoxication is available. Then we have section 86. Section 86 simply says that there might be a situation. In that situation, or there might be certain offense which requires specific knowledge, a particular knowledge, or particular intent which is there as an ingredient of that offense. मतलब उस offense को constitute करने में ही knowledge और intent की requirement होती है. Knowledge and specific intent is itself an ingredient of, say, a certain offense. Then if any person who has intoxicated himself voluntarily, then on that person the knowledge requisite which is there, that knowledge is imputed. The intention part is not imputed if the person has voluntarily intoxicated himself. मतलब अगर किसी ऑफेंस में स्पेसिफिक नॉलेज की जरूरत है, knowledge that act is likely to cause the death. So if knowledge is required for constituting offense under any of the provisions of the Indian Penal Code, and the person has voluntarily intoxicated himself, then whatever act he is doing, the knowledge that he is likely to have will be presumed upon himself. He cannot claim the benefit of intoxication. However, if any offense requires specific intention, जैसे थेफ्ट के केस में डिसऑनेस्ट इंटेंशन चाहिए होती है. अब कोई इंसान अगर ऐसा इंटॉक्सिकेटेड हो गया voluntarily had intoxicated himself to such an extent that he is unable to understand the nature and consequence, and he's not with a dishonest intention, meaning thereby to cause himself a wrongful gain. He took certain property. So, suppose in this case of theft, a specific intention is required to constitute the offense of theft. And by reason of voluntarily intoxicating himself, a person is unable to form that intention. So section 86 says that the intention is generally not imposed, only the knowledge part is imposed. That is all about section 86. Here we see that in cases where an act is done is not an offense unless done with particular knowledge or intent, a person who does the act in the state of intoxication shall be liable to be dealt as with if he had the same knowledge as he would have if he had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge or against his will. So if intoxication was involuntary, then both the things will not be imputed. Okay, so this is there. So this is all about the defense of intoxication. In intoxication, certain important cases that you need to remember is only few cases we'll see, those which are really very important. DPP versus Beard. Then you have Basudev versus State of Pepsu. Then you have R versus Lipman. Then you have AG for Northern Ireland versus Gallagher. So these are some of the important cases which are there, which deals with the defense of intoxication. Directorate of Public Prosecution versus Beard. In this case, what happened was a watchman was there. He was intoxicated, and he ravished a girl who was there. And in the due process, the girl died as she was suffocated. So in this case, intoxication defense was not available. Then another case of Basudev versus State of Pepsu is there. That also you must have been remembering. In this case, a military personnel was there. He was attending a wedding party. And in that wedding party, a child was there who was occupying a seat. He was intoxicated, obviously. He wanted that seat. The child refused, and then he shot him. Another case was R versus Lipman. R versus Lipman में क्या हुआ था? Lipman was there and a girl was there. They were basically under influence of drug LSD. And under such influence of drug LSD, they were under the hallucination that they are descending down the surface of the earth and they were being attacked by the snakes. And in that process, Lipman basically hit 2 blows to the girl and the girl died. In this case, the defense of intoxication was there. Particular intent, mitigating factor was there. Particular intent, requisite intent which was there was not found. So he was not held liable for murder, rather he was held liable for manslaughter. Then Attorney General for Northern Ireland versus Gallagher case is there. Psychopath was there. He got aggravated by the drinks. And then he killed a person. So this was some of the important cases which are related to the defense of intoxication. Now we'll deal with the defense of, or we'll deal with the cases relating to the consent. Section 87 to 91, we can see. Similarly, briefly we'll quickly understand what these sections are all about and what are the aids to remember these sections. Section 87, as you already know, these sections you have to remember by what? By the illustrations. If you'll try to remember these sections which deals with the consent by the illustrations, मतलब example जो दिए हुए हैं इस section में, section को example के wise अगर आप याद करोगे, याद करने की कोशिश करोगे, तो then ये जो है आपको भूलेगा नहीं. तो अक्सर होता है कि these sections people often get confused whether this was in section 87, 88, 89 or 90. Other are very simple, only one section is there with respect to a particular topic, so that are easy to recall. But these sections are some way, if you are not regularly revising, you might tend to forget. Section 87 says that act not intended or not known likely to cause death or grievous hurt done by the consent. So firstly, what is consent? Consent has not been defined, but section 90, if you'll see, it gives a broad outline of what the consent is all about. A consent is not a consent if it is given under a fear of injury or under a misconception of fact. So, when a person gives consent, which is contemplated under the Indian Penal Code, wherever it is there, if the consent is caused by the fear of injury or misconception of fact, then it will not be treated as a consent. Similarly, if a person is of unsound mind, if a person is under the influence of intoxication, so that he is unable to understand the nature and consequence of his act, then also the consent is vitiated. Similarly, consent of a person who is below the age of 12 years, unless the context otherwise provides, that is also not a consent. Meaning thereby some sections are there in which a person can validly consent up to 18 years. So that will supersede. But generally, if no contrary context is there, then generally consent of a child below the age of 12 years is not a valid consent. So general outline or general guideline relating to the consent has been provided under section 90. But the consent has not been defined under the Indian Penal Code. What is not consent or what is where the consent gets vitiated, that is given. Now, act not intended, whenever you consent, a person cannot consent for his voluntarily causing of death or of grievous hurt. But if a person has voluntarily consented for the causation of his death, then we see that a mitigating factor is there. One of the exception is there for the murder, in which the consent is there. मतलब जनरली कंसेंट देके कोई पर्सन अपनी डेथ कॉज नहीं करवा सकता है, लेकिन वहां पे लाइबिलिटी जो है थोड़ी रिड्यूस हो जाती है. कल्पेबल होमिसाइड अमाउंटिंग टू मर्डर से कल्पेबल होमिसाइड नॉट अमाउंटिंग टू मर्डर ये हो जाता है. सो जनरली द रूल इज दैट अ पर्सन कैन नॉट voluntarily consent for causation of his death. Apart from that, what are the relevant sections which are there which deals with the consent? Section 87, 88, 89 is there. Then 91 and also 91 is there. 92 deals with act done without the consent. And 93 was communication made in good faith. So we'll properly deal with this. Section 87 says that nothing is which is not intended to cause death or grievous hurt. So intentional causing of death and intentional causing of grievous hurt is not protected under the defense of consent, which is there under the general exception. So nothing which is not intended to cause death or grievous hurt and which is not known by the doer, also the knowledge part, not known by the doer to likely to cause death or grievous hurt, is an offense by reason of any harm which it may cause. So intentional causing of death, intentional causing of grievous hurt is excluded, or knowledge that any act is likely to cause death or grievous hurt is an offense by reason of any harm which it may cause or be intended by the doer to cause to any person above 18 years of age who has given consent. So other harm may be caused if a person has given a consent and that person was above 18 years of age. But that harm should not include to the intentional causing of death or the intentional causing of the grievous hurt. Every man is the best judge of himself. We already know, we must have studied the law of torts, and that we understand there is this maxim volenti non fit injuria. So generally, section 87, what is the common example which is given under section 87? Is the cases of wrestling, cases of fencing. So wrestling और fencing में हार्म तो कॉज हो जाती है, इंटेंशनली और नोइंगली भी आदमी हार्म कॉज करता है, लेकिन फिर भी ही इज नॉट हेल्ड लायबल बिकॉज द अदर पर्सन हैज कंसेंटेड ना. सो the cases of wrestling, the cases of fencing is covered under section 87. The person is not intentionally and not knowingly he has caused the death or the grievous hurt. And if he has caused any harm, though it may extend, but it was not intentional causing of death or grievous hurt. And if he has caused any other harm with the consent of a person who is above the age of 18 years, then it will not be treated as an offense. The consent may be either express consent or implied consent. Express consent or implied consent to what? To suffer the harm, or by reason of any harm which it may be known by the doer to likely to cause to any such person who has consented to the risk of that harm. So every man is the best judge of himself. Section 87 basically covers those cases of wrestling, fencing, sports activity, and it will not extend to the voluntarily causing of death or grievous hurt. So first essential is the act should not be intended to cause death or grievous hurt. It should not be known to likely to cause death or grievous hurt. It must be done with the consent of a person who is above age of 18 years, and it must be in good faith. Okay. So these are some of the important elements under section 87. Section 87 को कैसे याद रखेंगे? इस एग्जाम्पल से, यहाँ पे दिया भी है, A and Z agree to fence with each other. Then section 88 is there. Section 87 में important केस आपको पता ही होंगे. सुक्रू कविराज का केस था. For operation of internal piles, the person used very ordinary knife. So the defense of consent was not available, as no good faith was there. Similarly, Pune Fatima's case, Pune Fatima case, सुक्रू कविराज केस, ये दोनों कंसेंट से रिलेटेड है. 87 में आप देख सकते हो. Pune Fatima में केस is related to what? The snake charmer case. Person professed to be a snake charmer and he believed that he had the power to cure from snake bite. So this was the case, Pune Fatima's case and Sukru Kaviraj case. They both deal with this topic. Then we have section 88. Act not intended to cause death. 88, 89 और 92 ये साथ पढ़ा जाता है. 88 हो गया, 89 हो गया, and section 92. All these three sections, 88, 89 and 92, deals with what? When an act is committed by any person for the benefit of another person in good faith. मतलब कोई एक्ट कमिट हुआ किसी पर्सन के बेनिफिट के लिए इन गुड फेथ. 88 और 89 में कंसेंट होती है. इन 88 एंड 89 देयर इज प्रेजेंस ऑफ द कंसेंट, while under section 92 the same thing is there, but that act is done without the consent. All the effect will deal one by one. Section 88, section 87 मैंने बता दिया रेसलिंग का होता है. Section 88 होता है सर्जन का एग्जाम्पल. आप जाते हो अपनी सर्जरी कराने या डॉक्टर के पास जाते हो, and then when you go to the doctor then you sign that declaration or sign that consent. You consent to whatever harm, or what you sign this consent form. So these cases are covered under section 88. You may also consent on behalf of your children for the same operation or surgery. That is covered under section 89. However, the surgeon, if he finds that your consent cannot be obtained, or it's impossible to obtain your consent, or if any minor is there, then the guardian's consent cannot be obtained within due time, then even without the consent, a person can act for the benefit of another person in good faith. And he can take the risk of incurring any harm that is there. He will not be held liable. Okay. So all these three cases deals with these topics. Act done in good faith for the benefit of Act 88, firstly we'll deal with. Act not intended to cause death, done by consent in good faith for person's benefit. So here we see the act is done for person's benefit. Here also the act is done for person's benefit. And it is done in good faith. Okay. The act is done for person's benefit. It is done in good faith. It's done in good faith. It's done with consent of the person himself. Of if that person is a child, insane person, or a person who is having a guardian, then with the consent of that child or insane person. Consent of the guardian of that child or insane person, or any person who is lawfully interested. With that consent, an act can be done in good faith for the benefit of such child or insane person. Section 80 says that 88 says that nothing which is not intended to cause death. Again, intentional causing of death cannot be protected. Is an offense. So nothing is an offense by reason of any harm which it may cause, or be intended by the doer to cause, or by known by the doer to likely to cause, to any person for whose benefit it is done, in good faith, and who has given a consent, whether express or implied, to suffer that harm. So section 88 का common example कहाँ आता है? जब आप किसी सर्जन के पास जाते हो, किसी डॉक्टर के पास जाते हो. So here you will find that example. A surgeon, knowing that a particular operation is likely to cause the death of Z, who suffers under the painful complaint, but not intending to cause Z's death. He is not intentionally intending that his death would be caused by any such operation or surgery, and intending in good faith, secondly, with the consent. Good faith है, no intention of causing death है, consent है, benefit के लिए है, okay, for benefit of that person, then he has committed no offense if he has done such operation. Okay. Similarly, we have section 89. All the things are very similar, just the difference is about the person who is giving the consent. In that case, since the person is not a child or an insane person, he can himself consent. However, there might be a situation that an act might be done, or a doctor needs to perform an act for the benefit of a child or insane person, and a child and insane person, by virtue of section 90, we know that they are incapable of giving consent. Then who will give consent? Obviously, the guardian who is there. Nothing which is done in good faith for the benefit of a person under 12 years of age or of unsound mind, or by consent either express or implied of the guardian or other person having lawful charge of that person, is an offense by reason of any harm which it may cause or be intended by the doer to likely to cause to that person. Section 89. इसके 3 प्रोविजो भी हैं, अरे 4 प्रोविजो हैं, फर्स्ट सेकंड। ये जो फर्स्ट सेकंड और फोर्थ प्रोविजो है ये सिमिलर है सेक्शन 92 के प्रोविजो से भी। यहां पे थर्ड जो प्रोविजो है इसमें स्लाइटली देयर इज डिफरेंस इन विद सेक्शन 92। दिस इज द डिफरेंस। बिकॉज इसका एग्जाम्पल क्या है, एक तो एग्जाम्पल कॉमन आपको सेक्शन 89 याद रखने के लिए वो ये होगा कि यू कैन कंसेंट टू परफॉर्म अ सर्जरी ऑन योर चाइल्ड to the doctor for his benefit in good faith, and if the doctor does that, obviously he is protected. Similarly, this section is also attached with provisos. Proviso says that this exception shall not extend to the intentional causing of death. Very well, we know that. This exception shall also not extend to doing of anything which the person knows to likely to cause death. So intentional or knowledge, both the things are covered for any purpose other than the purpose of preventing death or grievous hurt. The third one says that this exception shall not extend to the voluntarily causing of grievous hurt or to the attempting to cause grievous hurt, unless it be for the purpose of preventing death or grievous hurt or for the curing of grievous disease or infirmity. Voluntarily causing of grievous hurt में नहीं extend करता है। ग्रीवियस हर्ट का स्कोप जो है वो कम होता है। जो स्कूल टीचर्स होते हैं, इन ऑर्डर टू इनकलकेट डिसिप्लिन इन द स्कूल, दे कैन इन्फ्लिक्ट माइनर पनिशमेंट्स ऑन द चिल्ड्रन एंड द पेरेंट्स दे कंसेंट फॉर दैट, सो दे ऑल्सो गेट प्रोटेक्शन अंडर सेक्शन 89। सो ये भी एक एग्जाम्पल है। यही डिफरेंस हो जाता है क्योंकि सेक्शन 92 में यहां पे हर्ट दिया हुआ है, थर्ड प्रोविजो में हर्ट दिया हुआ है, तो उसका स्कोप ब्रॉड होता है, इसका स्कोप लिमिटेड हो जाता है। सो दैट इज व्हाई द स्कूल टीचर्स दे गेट एग्जेम्पशन। फोर्थली, दैट दिस एक्सेप्शन शैल आल्सो नॉट एक्सटेंड टू द अबेटमेंट ऑफ एनी ऑफेंस टू द कमिटिंग ऑफ विच ऑफेंस इट वुड नॉट एक्सटेंड। अगर ऑफेंस में नहीं एक्सटेंड कर रहा है, अबेटमेंट में भी नहीं एक्सटेंड करेगा। ए इन गुड फेथ फॉर हिज चाइल्ड्स बेनिफिट विदाउट हिज चाइल्ड्स कंसेंट has his child cut for the stone by a surgeon knowing it to be likely that the operation will cause the death, लेकिन intention नहीं है, but not intending to cause the child, rather it's for the benefit of that child. A is within the exception. Then we'll quickly see section 92, act done in good faith for the benefit of person without consent. So here the important thing is that certain acts can be done, generally consent is required of the guardian or the person himself, but if the situation is such, circumstances are such that it is impossible for the person to signify consent, or if the person is incapable of giving consent and has no guardian who can consent on his behalf, because such is the situation. अभी कोई पर्सन, उसको टाइगर ने अटैक कर दिया है, टाइगर उसको उठा के ले जा रहा है, अब उसकी कंसेंट तो मांगने का समय है नहीं। he can incur the risk of shooting at the tiger, though he is not intentionally, but he knows he is not intentionally causing death, but he knows that he might cause the death of the person as his shot might get missed, but for his benefit, in order to save him, he fires at the tiger. Obviously he will get the protection. Here he has not given consent, so without the consent of the person, even also certain acts may be exempted from criminal liability. Almost everything is same, just here the scope is wider, as the expression is used as hurt. Okay, इसके एग्जाम्पल याद रख लेना। इसके एग्जाम्पल क्या क्या है? अब नाउ इफ अ डॉक्टर इज देयर and a person has suffered an attack, now that doctor, he knows the CPR, but in CPR you know that many a times the rib gets broken, and the doctor cannot, it's not visible, it's not feasible that the doctor should firstly see whether what is his contact, and then he gets the consent, immediately he has to give the CPR, na, in order to save his life for his benefit. Then his action is basically covered under this exception. Z is thrown from his horse as is insensible. A surgeon finds that he requires to be trepanned. So trepanned का example वो भी इस section में है. कौन सा section? 92 without consent. 88 89 में consent होता है, 92 में consent नहीं होता है. Carried off by a tiger, ये example मैंने बताया. Surgeon sees a child suffer an accident. He performs the operation despite the consent and despite the entreaties for his benefit. Then also he is saved. A is in a house which is on fire with Z, a child. This is very important. Often people forget this illustration, where this illustration is given. घर में आग लगी है, ऊपर एक बच्चा है, नीचे लोग चादर लेके खड़े हैं. उस बच्चे की लाइफ को सेव करने के लिए उसने जो है गिरा दिया. नॉलेज है कि हो सकता है इसकी डेथ हो जाए, लेकिन उसके बेनिफिट के लिए, उसको सेव करने के लिए किया. ये ब्लैंकेट वाला एग्जाम्पल जो है ये आप याद रखिएगा, सेक्शन 92 में आता है. सर्जन वाला एग्जाम्पल, विदाउट द कंसेंट इफ सर्जरी इज डन, carried off by a tiger, and then again a similar example, trepanned for surgery. These all are given under section 92. Offenses independently act which is independently of the harm caused. ये कल ही मैंने आपको बता दिया था, 92 हो गया. Communication made in good faith. No communication made in good faith is an offense by reason of any harm to the person to whom it is made, if it is made for the benefit of that person. So अगर कोई communication किया है किसी ने, good faith में किया है, for benefit of that person है, लेकिन वो निकल के आया कि उससे अगले पर्सन को हार्ट अटैक आ गया, so his liability would be exempted under section 93. जैसे सर्जन का केस है, गुड फेथ होनी चाहिए, बेनिफिट होना चाहिए. सर्जन ने गुड फेथ में कम्युनिकेट कर दिया कि ही इज सफरिंग फ्रॉम कैंसर, एंड द पर्सन इमीडिएटली ही सफर्स अ कंकशन and he suffers from a heart attack. So if the surgeon had made this communication in good faith for his benefit so that he might get remedy on proper time, so then his act is basically exempted. Act to which a person is compelled by threats, section 94. इसमें क्या है? दो चीज हटा दो, मर्डर हटा दो और ऑफेंसेस अगेंस्ट द स्टेट विच इज पनिशेबल विद डेथ हटा दो. ये दो चीज हटा दो. मतलब किसी ने अगर आपको कंपेल किया तो आप किसी का मर्डर कॉज नहीं कर सकते हो. किसी ने अगर आपको कंपेल किया तो ऐसा ऑफेंस अगेंस्ट स्टेट नहीं कॉज कर सकते हो जिसमें डेथ से पनिशेबल हो. सो इफ these things are exempted, then nothing is an offense which is done by a person who is compelled to do it by what? By threats, which at the time of doing it reasonably cause the apprehension that instant death to that person will otherwise be the consequence. अब इसमें proviso है. Provided that the person doing the act did not of his own accord or from a reasonable apprehension of harm itself short of instant death place himself in the situation by which he became the subject to such constraint. खुद से नहीं ऐसे वहां जाके ज्वाइन कर लिए गैंग ऑफ डकॉइट, और फिर बाद में जो डकॉइट हैं अपने ही एक्ट से आपने गैंग ऑफ डकॉइट को ज्वाइन कर लिया. अब गैंग ऑफ डकॉइट जो है वो आपको कंपेल कर दिया उन्होंने कोई ऑफेंस कॉज करने के लिए, एक्सेप्ट मर्डर, एक्सेप्ट पनिशेबल विद डेथ, देन द डिफेंस इज नॉट अवेलेबल. अपने ही खुद से ही वॉलंटरली नहीं है. लेकिन however, if you are doing something and the gang of dacoits have seized you, kidnapped you, and then they have compelled you to commit any offense other than murder and then offense punishable with death against the state, then the defense is available. Okay. Act causing slight harm. Act causing slight harm क्या है? Trivial act, section 95. De minimis non curate lex. लॉ डज नॉट टेक अकाउंट ऑफ द ट्राइफल्स. आपके दोस्त ने आपको एक थप्पड़ मार दिया, आप उसके ऊपर हर्ट का केस नहीं कर सकते हो. ओके. नथिंग इज एन ऑफेंस विच इज Nothing is an offense by reason that it causes or that it is intended to cause or that is known to be likely to cause any harm if that harm is so slight that no person of ordinary sense and temper would complain of such harm. Trivial acts. Okay. So this was about section 76 to 95. The other part, very important part of the right of the general exception is right of the private defense. Mostly it's the justifiable acts which are there. Right of private defense has been dealt under section 96 to 106 of the Indian Penal Code. इसका सिंपल मैं आपको ब्रॉड आउटलाइन बता देता हूँ. अक्सर रिवाइज ना करो टाइम पे तो भूल जाता है. 96. बस दो चीज आपको याद रखनी है. 101, 100, 101, 102, 103, 104, 105. बस 6 सेक्शन यही हो गए ऐसे ग्रुप में. 100, 101, 102, 103, 104, 105 ये ग्रुप में. राइट ऑफ प्राइवेट डिफेंस ऑफ बॉडी, राइट ऑफ प्राइवेट डिफेंस अगेंस्ट प्रॉपर्टी. In both these cases, 100 and 103, it will extend to the causing of death. In both these cases, they deal with other than death. Both these sections deal with commencement and continuance. Commencement and continuance. Okay. So these three sections specifically deals with right to private defense of body, and these three sections specifically deals with right to private defense of property. ये 3 सेक्शन अगर याद है तो बाकी स्टोरी बड़ी सिंपल हो जाती है. Rest are general sections. 96, 97, 98, 99. 99 you already remember, very popular section. It deals with the limitations on the right to private defense. Right to private defense कोई absolute right थोड़ी ही ना है, उसमें limitation है. Limitation कहाँ दिया है? 99 में दिया है. फिर 96 is general section which says that nothing is an offense which is done in the exercise of the right of private defense. A right of private defense का scope क्या है? Against body का scope क्या है? Against property का scope क्या है? वो 97 में दिया है. 98 में ये दिया हुआ है, if a person is a child, insane or intoxicated person, his act is not an offense. Whether against that person you can exercise the right of private defense. Yes, this is given under section 98. Section 99 limitation हो गया. 100, 101, 102 right to private defense of body. 100 में right of private defense of body extend to the causing of death. Under 101 right of private defense of body extends to the causing of any harm other than that has been mentioned under section 100. Other than death, any other harm can be caused. 102 deals with the commencement and continuance of the right of private defense of the body. 103, 104, 105 similarly deals with corollary in respectively the right of private defense of the property. And then we have finally section 106. Section 106 क्या है? Section 106 is that the right of private defense can also extend, generally it is against whom? Either the wrongdoer or the assailant. Under section 106 it may extend even to an innocent person. So सारे सेक्शन ऐसे जो है लाइन में आपको लग गए हैं. 96, nothing is an offense. Oh, रुको एक सेकेंड. ठीक है. So right of private defense of body is there, right of private defense of this is there, right of private defense of property, this right of private defense of body, this has been covered under 100, 101, 102, this has been covered under 103, 104, 105. Okay, so this is there. 96 is there, nothing is an offense. 97, scope of the right of private defense. 98, insane intoxicated person के अगेंस्ट राइट टू प्राइवेट डिफेंस है कि नहीं? हाँ है. 98. 99, लिमिटेशन क्या है राइट ऑफ प्राइवेट डिफेंस? पब्लिक सर्वेंट के अगेंस्ट नहीं होता है. एनी पर्सन हु इज एक्टिंग अंडर द अथॉरिटी ऑफ पब्लिक सर्वेंट, उसके अगेंस्ट भी राइट ऑफ प्राइवेट डिफेंस नहीं होता है. इसके वो भी हैं, एक्सप्लेनेशन भी हैं, उसको देख लेंगे. सिमिलरली मोर हार्म देन दैट इज रिक्वायर्ड, दैट इज ऑल्सो नॉट परमिटेड. लिमिटेशन है ना, आपने किसी ने आपको थप्पड़ मारा, आपने उसकी जान ही ले ली. मोर हार्म देन दैट इज रिक्वायर्ड इज नॉट परमिटेड. सिमिलरली इफ रिकोर्स इज अवेलेबल टू द पब्लिक अथॉरिटी, बगल में थाना है, थाना नहीं गए, खुद ही लगे लड़ने, दैट इज ऑल्सो नॉट परमिटेड. सो दीज आर द लिमिटेशंस. देन we'll deal with in detail all these sections, what they are all about. Here you will see. Nothing is an offense which is done in the exercise of the right of private defense. Section 96. Very simple. Right of private defense of the body and right of private defense of the property. What is the scope? Right of private defense serves a very important social purpose. Krishna and others versus the state of UP. The right of private defense is a very valuable right serving a social purpose and should not be construed narrowly. Obviously, the state is there. State cannot protect you at all times. Where an apprehension of danger or apprehension of offense is there against you, it is impossible for the state to avert that apprehension or to avert the commission of an offense. So generally it's that expediency for which the right of private defense is given to every person. It says that every person has a right. It is not limited only to the citizens. Every person has a right subject to the restrictions contained in section 99 to defend, meaning thereby right to private defense is a defensive right. Right to private defense cannot be used under the pretext of committing any retributive act, committing any revengeful act. उसके लिए नहीं यूज किया जा सकता है. So you have right to private defense of the body and of the property. Body meaning thereby your own body. You can protect your own body against any offense, or you can prevent any other body, any other person's body from any offense. Others body के रिस्पेक्ट में फेमस लीडिंग केस कौन सा है? विश्वनाथ. ये इसको याद रखिएगा. राइट टू प्राइवेट डिफेंस में दो ही इंपॉर्टेंट केस हैं जो लीडिंग है, हालांकि केस तो बहुत है. विश्वनाथ वर्सेस स्टेट ऑफ यूपी. विश्वनाथ वर्सेस स्टेट ऑफ यूपी में क्या हुआ था? एक अमजद खान वाला केस है. अमजद खान वाले केस में क्या हुआ था? शॉप के बाहर लोगों ने घेर लिया था. शॉप में छुपा था, बाहर लोगों ने घेर लिया था. वो बच के जाए कहां? ही हैड द राइट टू प्राइवेट डिफेंस. दूसरा केस है विश्वनाथ वर्सेस स्टेट ऑफ यूपी. इसमें जो है द वाइफ वाज देयर, वाज अबडक्टेड बाय द हस्बैंड एंड ब्रदर एक्सरसाइज द राइट टू प्राइवेट डिफेंस ऑफ हर सिस्टर and caused basically it was stated that it can extend to the causing of death of that person. Okay, So you have the right to defend your own body or the body of some other person. Okay. And also, secondly, you have a right to private defense also to defend any property, whether it may be a movable property or it may be a movable property, from particular offenses against property which is mentioned under these sections. What are those offenses? कैसे याद रखेंगे? राइट टू प्राइवेट डिफेंस ऑफ जो प्रॉपर्टी है, अगर ऑफेंसेस अगेंस्ट ह्यूमन बॉडी है, उसके अगेंस्ट राइट टू प्राइवेट डिफेंस ऑफ बॉडी एक्सरसाइज कर सकते हैं. अगर कोई ऑफेंस अगेंस्ट प्रॉपर्टी है, तो सारे ऑफेंस अगेंस्ट प्रॉपर्टी के रिस्पेक्ट में यू कैन नॉट एक्सरसाइज द राइट टू प्राइवेट. ओनली सर्टेन ऑफेंसेस विच आर गिवन अंडर सेक्शन 97 with respect to those offenses against property only you can exercise the right of private defense. इसको याद करने का तरीका क्या? अक्सर लोग मिस कर जाते हैं. थ्रो मिस्ट्रेस, थ्रो मिस्ट्रेस, मिस्ट्रेस को जो है भगा दो. थ्रो मिस्ट्रेस. थेफ्ट, रॉबरी, मिसचीफ, क्रिमिनल ट्रेसपास. ये 4 सेक्शन है, ये 4 ऑफेंसेस हैं. सो राइट टू प्राइवेट डिफेंस ऑफ द प्रॉपर्टी, every person has the right subject to the restrictions to defend the property whether movable or immovable of himself or of any other person against any act which is an offense falling under the definition of theft, robbery, mischief or criminal trespass, or which is an attempt to commit theft, robbery, mischief or criminal trespass. अच्छा ये मिस हो गया, यही है, यहां पे देख लो अगर आप. थेफ्ट, रॉबरी, मिसचीफ एंड क्रिमिनल ट्रेसपास. ओके. So right to private defense of body is there, right to private defense of property is there. Right of private defense against the act of a person of unsound mind. So यहां पे क्या लिखा है? His own body and body of any other person against any offense. Your right of private defense is against any offense. Your right of private defense is against the offense of under the definition of theft, robbery, mischief and criminal trespass. What will be the scenario as we already are studying general exceptions? General exception में अगर कोई unsound person who is incapable of knowing the nature of consequences of his act, he is committing that act. Section 84 says that nothing is an offense. अरे भाई जब nothing is an offense है और यहां पे कह रहा है कि it is available against an offense, 84 में कह रहा है nothing is an offense, तो क्या against such act of an intoxicated person, against such act of an infant, against such act of an unsound person, since the scope of right of private defense specifically mentions that it should be an offense, and 84 says that nothing is an offense, 82 says that nothing is an offense, then will there be a right of private defense? Obviously yes, because section 98 says so. Section 98 में यहां कहता है कि when an act which would otherwise be an offense if not is an offense by reason of youth, 82, want of maturity of understanding, 83, unsoundness of mind, 84, intoxication, 85, of the person doing that or by reason of any misconception of the misconception on the part of that person, 76, 79. Every person has the same right of private defense against that act which he would have if it were that offense. So generally he would be exempted by virtue of general exception. But for exercise of right of private defense, it would be treated that it is still an offense. Okay. So that you have the right of private defense against such act of an unsound person. मतलब Z अगर influence of madness में अगर आपके ऊपर अटैक कर दिया, his act is not an offense. अगर उसको पता ही नहीं है, पागलपन में उसने आपके ऊपर अटैक कर दिया, क्या आपके पास राइट ऑफ प्राइवेट डिफेंस है? ऑब्वियसली है. उसका एक्ट ऑफेंस नहीं है, लेकिन 98 उसको कवर कर लेता है. सो दैट इज वेरी सिंपल. Section 98 covers that. Section 99 talks about limitation on the right of private defense. 4 limitations are there. Act done by a public servant in good faith under the color of the office. Even though the act is not strictly justifiable by law, you have no right of private defense. Act done under the direction of a public servant, in good faith, under the color of the office, even though it's not justifiable, you have no right of private defense. You cannot cause more harm than that is required. Is the third limitation. Fourth limitation is basically that you cannot exercise the right of private defense when you have appropriate time to have recourse to the public authorities. Okay, so this is there. Explanation is also there. A person is not deprived, meaning thereby अगर कोई public servant है और you have no right of private defense against a public servant. But if you neither know nor you have reason to believe that that person is a public servant or that person is acting under the direction of a public servant, then your right of private defense, if you don't have the reason to believe, if you don't know, then your right of private defense is still available. Okay. It says that a person is not deprived of his right of private defense against an act done by a public servant unless he knows or has reason to believe that the person doing the act is public servant. Okay. मतलब अगर आपको पता ही नहीं है या कोई रीजन टू बिलीव भी नहीं है कि जो पर्सन है he is a public servant acting under the color of the office, in good faith he is acting, you neither have the knowledge nor you have the reason to believe that thing, then you are not deprived of your right of private defense. Similarly, against the public servant, another important limitation is there, that the public servant is acting in good faith under the color of his office, and the act of the public servant is not causing reasonable apprehension of death or of grievous hurt. If reasonable apprehension of death or grievous hurt is there, then your right of private defense is available, because it says that there is no right of private defense against an act which does not cause reasonable apprehension of death or grievous hurt if done or attempted to be done by a public servant in good faith in the color of his office. Okay, so very simple it's there. ये हो गया. Then right of private defense of, अब 101, 100, 101, 102 पे आ जाते हैं. Private defense of the body पे डिटेल में. It will extend to the causing of death in what circumstances? 7 circumstances are there. अगर कोई ऐसा assault है, assailant जो है, कोई ऐसा assault करता है कि you have the apprehension that the death will otherwise be the consequence. ऐसा apprehension हो जाए कि death हो जाएगी. Assault ऐसा है कि it may reasonably cause the apprehension that grievous hurt, so death हो गई, grievous hurt हो गया, rape हो गया, unnatural lust हो गया, kidnapping, abduction हो गया, and then wrongful confinement ऐसा that under the circumstances it causes the apprehension that you will not have recourse to the public authority. And then lastly, added by the recent amendment 2013, act of throwing or administering acid or an attempt to throw or administer acid which may reasonably cause the apprehension that the grievous hurt will otherwise be the consequence. So ये 7 clauses हैं wherein the right of private defense extends to the causing of the death. In other scenario, section 101 says that in those circumstances other than the one which is mentioned in section 100, the person can cause any harm other than the death. If offense not be of the description enumerated in the last preceding section, the right of private defense of the body does not extend to the voluntary causing of death, but does extend under the restrictions. अब restrictions में ये दिया है कि more harm than that is required should not be caused. कोई अगर थप्पड़ मार रहा है तो आप उसको जो है उसकी डेथ कॉज नहीं कर सकते हो, उसको ग्रीवियस हर्ट कॉज नहीं कर सकते हो. डेथ तो ऐसे ही प्रोहिबिटेड है. ग्रीवियस हर्ट आप नहीं कॉज कर सकते उससे. इट मस्ट बी rational and proportionate depending upon the facts it will be seen. Commencement and continuance. So whenever the apprehension of danger arises, apprehension of danger against whom? Against the body arises, the right commences and it continues until such apprehension of danger is continuing. Okay, so this is being given under section 102. यहां पे आप देख लो. Commences as soon as the reasonable apprehension of danger to the body arises, and it continues as long as such apprehension of danger of the body continues. Okay, so this is there. Then we have right to private defense of the property. Right to private defense of property extends to the causing of death given under section 103. इसमें जो है पहले आपको जो राइट टू प्राइवेट डिफेंस ऑफ प्रॉपर्टी है वो जनरली एक्सटेंड करता है 4 ऑफेंसेस के अगेंस्ट: थेफ्ट, रॉबरी, मिसचीफ एंड क्रिमिनल ट्रेसपास. इसी के जो एग्रेवेटेड फॉर्म्स हैं, रॉबरी तो दोनों में है, इसके एग्रेवेटेड फॉर्म जैसे हाउस ब्रेकिंग बाय नाइट, mischief by fire in a place which is used for dwelling, theft, mischief or house trespass in such a circumstance that may reasonably cause the apprehension of death or grievous hurt will otherwise be the consequence. In these 3 cases, the right of private defense of property extends to the causing of death. Robbery is also included. ये जो है 4 cases are there: robbery, house breaking by night, mischief by fire in any building, tent or vessel which is used for human dwelling, and then finally theft, mischief or house trespass which causes apprehension that death or grievous hurt will otherwise be the consequence. So in these cases, right of private defense of property extends to the causing of death. Aggravated forms हैं इन सब offenses के. Other harm, when the scenario is not covered under section 103, मतलब जनरल other offenses against property है, then it will extend to the causing of any harm other than the death. Then we come to the commencement and continuance of the right of private defense of property. इसमें थोड़ा different है. Commencement तो same होता है. Commences when a reasonable apprehension of danger to the property arises. इस पे क्वेश्चन आ गया है, ध्यान देना है, ये सेक्शन मिस मत करना, क्योंकि अभी आप मिस कर दिए. एग्जाम में यही इसी पे क्वेश्चन आता है, यहीं पे अटका देता है. एंड देयर इज नो स्कोप ऑफ एरर, कमिटिंग एनी एरर अंडर दिस सेक्शन, बिकॉज बिलीव मी, एवरी सीरियस एस्पिरेंट knows each and every aspect of whatever it is given under the general exception. So ये मत सोचना अरे ये तो इंपॉर्टेंट नहीं है, इस पे ध्यान नहीं दिया, आगे बढ़ गए तुरंत कि अच्छा ये सिंपल, जैसे ये सिंपल था राइट टू प्राइवेट कमेंसमेंट एंड कंटिन्यूएंस ऑफ प्राइवेट डिफेंस ऑफ बॉडी, वैसे ये भी सिंपल है. कमेंसमेंट तो पता चल गया, रीजनेबल एप्रीहेंशन ऑफ डेंजर. अब कंटिन्यूएंस में जो है अलग अलग, थेफ्ट में अलग है, मिसचीफ और ट्रेसपास में अलग है, और रॉबरी में अलग है. ये आपने ध्यान नहीं दिया और एग्जाम में इसी पे क्वेश्चन आ गया और आया है. जुडिशरी में भी आता है, अदर स्टेट्स में भी आता है, पीएसयू के एग्जाम में भी आता है, एपीओ में भी आ सकता है. तो आपको ये चीज ध्यान में रखनी है कि ऐसे इग्नोरेंट जो है, दीज टाइप ऑफ इग्नोरेंस you have to necessarily avoid. So commencement, we understand that when a reasonable apprehension of danger to the property commences, then the right of private defense commences against property. It commences. Continuance. Now with respect to the continuance as against theft, theft में 3 सिनेरियो है. It continues until the offender has effected his retreat with the property, or either assistance of public authorities is obtained, or the property has been recovered. Right to private defense of property against theft, इसके कंटिन्यूएंस में 3 पॉइंट हैं, वो याद रहने चाहिए. It continues until the offender has effected his retreat with the property, or assistance of public authorities obtained, or the property has been recovered. Simple question they will ask, and you might get confused in the terminology. So avoid that. In the case of robbery, it continues as long as the offender causes or attempts to cause to any person death, hurt, or wrongful restraint, or fear of instant death, instant hurt, or instant wrongful restraint. As long as there is attempt to cause such death, hurt, or wrongful restraint, such apprehension continues, or the fear of instant death, instant hurt, or instant restraint, it continues. As long as it continues, the right of private defense against the property, it continues. When it ceases, right of private defense against property also ceases. The right of private defense of property against criminal trespass or mischief continues as long as the offender continues in the commission of criminal trespass or mischief. So इसके respect में offences against property में 3 चीजें, these 3 things are there. As long as the criminal trespass or mischief continues, as long as the offender continues the offense of, continues to be in the offense of, continues to be in the state of trespass and mischief, the right of private defense will extend. Similarly, robbery के case में, as long as the fear is there, as long as the offender causes or attempts to cause the death, hurt, or wrongful restraint. As long as, in the case of theft, as long as the offender has effected his retreat, as long as the assistance is obtained or the property has been recovered, until then the right to private defense of property will extend. Right to private defense against the offense of house breaking by night, it continues as long as the house trespass which has begun by such house breaking continues. House breaking by night के केस में कब तक करेगा? हाउस ट्रेसपास का ही एग्रीवेटेड फॉर्म है. As long as house trespass is continuing, house trespass is continuing, until then the right of private defense will also be available. And then lastly we have section 106 that I have already explained. If there is right of private defense which is available to you against an individual, ये किसके अगेंस्ट अवेलेबल होता है? यहां पे अगर आप देखो 97 में against any offense affecting every person has a right Here you will see the right of private defense of the body extend under the restriction to the voluntary causing of death or any other harm to the assailant. Here the word mentioned is assailant. Against whom the right of private defense is extended? Against the assailant. Similarly, in 101 we will see to the assailant. Here it is mentioned. Similarly, in the right of private defense of property, it is extended against the whom? Against the wrongdoer. So, right of private defense generally extends against whom? Either the assailant, in the case of right of private defense against body, and against the wrongdoer if he is basically exercising the right of private defense against property. But in these scenarios, there might be a situation that there is a mob, there is such circumstance in which I cannot effectively exercise my right of private defense without incurring the risk of causing harm to some other person who is not assailant, who is not the wrongdoer. He is an innocent person. Then my right of private defense is not limited by the presence of such third person, innocent person, who is not assailant or wrongdoer. Law gives me the right to run the risk of causing of that harm. यही दिया है section 106 में. A is attacked by a mob who attempted to murder him. He cannot effectually exercise his right of private defense without firing on the mob. And he cannot fire without risk of harming young children who are mingled with the mob. A commits no offense if by so firing he harms any of the children. Okay, so that's all for today. We'll continue the progression of our course. We have finished general exceptions. Okay. That's all, guys. कोई doubt है? Okay, guys. Thank you.